Trendsetter Award. So these are the small innovative ideas. So with that innovative ideas, we can make a product and we can go for a patent filing and other kind of IP that we can protect it also, right? And you see here these inventions like people, they are carrying this water for their home daily, so like 2-3 pots together, and they are carrying for long way. Okay, it is very difficult to carry these pots and all. Okay, so for that, to just get rid of all these things, then we can see here it is the another lady. She's carrying very easily with a roller. Okay, just like a tire, and inside, so they are having the water containing area, and we can just fill up that water, and we can just roll that water with a, like, even for a 1 kilometer, 2 kilometer also we can carry this water. So this is one innovative ideas. Okay, these inventions. And another one you can see here, this is very good innovations, no? Like this is the water you can eat as such. Okay, no plastic bottles are necessary, and here also you can just swallow it, and even that water will you can consume, and it will get dissolved. Okay, and this is another kind of innovation. Okay, and another one is this vada batter. Okay, and how to do this vada and all, and we have to take that. And with the hand we have to do it, and we have to wash with water everything. But here you can just open, and you can easily you can squeeze it. Okay, so it is ready to do all these things. Okay, already it is containing everything, and this is one kind of innovations, right? And even yeah, these are the about like the innovations. And when we are talking about this the IP policy, like the 2016, I told already they formulated the primary focus of this policy is towards promoting innovations and creativity. So that's what, because whatever the innovations we are seeing here, I have shown the slide. So the primary focus of this policy also is towards promoting the innovation and the creativity. Okay, especially amongst the entrepreneurs and in the higher education institutions also. Okay, and even all the institutions, the college and the universities, they are having the institutional IP policy also. And the policy generally brief specifically mentions synergizing all the forms of IPR, concerned statutes and agencies for tapping the creativity and the innovative energies in India, with a special emphasis on startups and educational institutions. So nowadays, all the institutes, they have also started with this innovations institution and innovation council. Through that, they have started this startup also, and entrepreneurship, entrepreneurial skills development also. All the institutes, they have started, and it is going on well. And the government of India funded by this RUSA scheme. They are through that RUSA scheme, many startup they have developed in their institutes. Also, the skill development programs also they have started. And the UGC know that in the University Grant Commission, the nodal authority for determining and maintaining the standards of university education in India, issued a letter recently for inclusion of this IP, intellectual property rights, as a generic elective subject under the choice-based accredited system. Even many universities, they are following, and for the undergraduate as well as the postgraduate courses, they have to add at least one paper or a unit we have to include in that syllabus. Okay, so that is. So here, the IP policy, there are 7 objectives. One is the creating awareness, innovation, balanced structure of legal framework, administration and management, commercialization of IPRs, enforcement and adjudication, and human capital development also. Okay, and why it is important nowadays for academic institutes? I think you might know, like recently they have announced this NARF, okay, National Institutional Ranking Framework. This is a ranking system adopted by Ministry of Human Resource Development. It ranks the institution of higher education in India. These rankings act as a mechanism for the institutions to include promoting innovation, research and development, while assessing their performance beyond the academics. Okay, so it's not only like teaching and evaluation or paper publishing and all. Okay, apart from that, the ranking also given based on these innovations and research and development. Okay, and one of the parameters considered with while ranking, and which is significant for our discussion in research and professional practice, that includes the IPRs and patents. Okay, both even they are giving a weightage for the published patents and granted also by students and faculty members, which has a weightage about 15 marks they are giving. So in that case, as a academic institutes, so we have to go with this IP policy, and we have to inculcate our students, and we have to develop this kind of IP practice in our institutes also. Okay, and when we are seeing this the IP policy, um, generally, like the IP policy, the creating awareness is everybody is giving nowadays. Started many programs, they have started to create this awareness. Then only people will come forward to talk about this IP, and they will also come to know that what is IP, what are the things involved in that. Okay, so for that, all the academic institutes, colleges, and universities, they have to start this creating awareness among the students and faculty members. So for that, in the awareness programs, a lot of programs they are giving, and of course the innovation. So we have discussed many things about the innovation. Innovation is very important. We have to encourage this innovation, innovative ideas among the students, and the balanced structure and legal framework. Each and every aspects, like the legal is involved, and in IP also they have very good legal structure are there, and we have to follow that legal framework. And administration and management also is very important. So, and the commercialization of IPs. Once if you are filing the patent, many people what they are doing that after filing the patent, they will just put in their curriculum, so the CV and resume their resume, and they will forget about. Even if it is granted, also they will not bother. Okay, it is not like that. Once your patent is granted, then simultaneously you have to think about this commercialization aspect. That is very important. Okay, so commercialization is very important. So without commercialization, your patent will not be a fruitful one also. And the enforcement and the adjudication is very important. Once if your patent is granted, then you have to keep on watch, because many people they will infringe your IP. Okay, so in that case you have to do a legal action, and you can file a suit a case, and you will get a lot of damages also. And another, finally, the human capital development, that is very important. The human capital development, because so we need the human capital, because many people we need to work on this IP and formulate, and to just give awareness to the people also. We have to develop that human capital based on this IP also. So these are the 7 objectives of this national IPR policy. And even the ranking of top educational institutions was found to be proportional to the number of applications for the patents also. Okay, filed, how many patents they have filed. So based on that only, that ranking also they are given. And there has been a significant increase in the application filed for patents, also research publications compared to previous 2 years. And nowadays all the institutes, they are showing that they have some filed a patent and published patents, and even some institutes they have granted also for last 2 years. Based on this ranking system, now this kind of practice also it is increased in our academic aspects. And suppose if you have a patent, okay, some questions will come. I have any invention. So what I have to do? How to approach? How to get this patent? Okay, because the protecting patents and the registration of patents, IPR management were giving a prominence in India, and it is the time to legalize the registration of patents. Otherwise, what will happen? Failing which, the research fruits of the person would be snatched by others, definitely. Okay, so whatever you have that innovative ideas or the novel ideas, so immediately you have to file the patent. So otherwise, you cannot discuss with others, and you cannot disclose also. So if you are disclosing, then immediately other people they will go and they file the patent. Okay, and also in the earlier days, the patenting was not much cased. Okay, but now the scene is changed totally, and considerably one had to think about think to have the patent for his survival, because of this liberalization and privatization concept. Okay, and this invention will not be fine if it is in mind. Okay, you can exploit your invention commercially only if you patent it. Otherwise, there is no use of doing this IP protection or patenting and all. Okay, and suppose if you have an questions, like I told you, like I have an invention. Okay, what you will do? One, you can just go to. There are two options. So you can publish it, or you have to approach the patent office. Okay, and when you are publishing, you can publish in the newspapers or media or journals, because then only the people will come to know that you have some idea and you have some technology or process that we can use it for some society benefits. Okay, or otherwise you will get publicity if the published invention is interested. It is a kind of publicity also. Okay, if you are keeping with you the inventions or innovative ideas, nobody will come to know that. So for that we have to publish it. If you file the patent application after publishing, you will not get the patent right also. Suppose the publishing in the sense, even you can file the patent in the patent office, they are publishing in their patent journals. Okay, so before publishing in the other medias and journals, you have to go to file the patent in the patent office, and the patent office also will publish the paper. After that you can present it anywhere, no problem. Okay, and the novelty of the invention is lost due to the publications. Okay, so once if you are decided to file the patent, first you go to the patent office and you file the patent, then you can go for simultaneously in the publication of your article or your ideas, everything. Okay, and the patenting in the patent office, you can file the patent application in the patent office, and you can also publish your invention after filing the patent application, and the patent office will also publish your invention in their journal. So the patent office is in India, government of India. So we have four patent office located, like in Mumbai, Delhi, Calcutta, and Chennai. It is jurisdictions, like in the southern India people now, like Kerala, Karnataka, and Andhra, Tamil Nadu. They have to file the patent in Chennai patent office. So like that, four patent offices located in our India, and we can file the patent also. So now we'll come to that. What is the importance of this intellectual property rights? So why now the academic institutes, they are talking more about this IPR? Okay, you know very well, the Indian industries and R&D institutes have not really excelled in the area of innovation due to various factors. Okay, but new this IP policy regime, like sounds really encouraging, and hence there is a need for institutional innovation to be encouraged and motivated continuously. Okay, and we can say intellectual property rights is a critical a tool for fostering the innovation. So I think all you will agree, the IPR a critical tool for fostering the innovation, and we have to manage judicially, and they balance private rights and public necessity in a manner that the overall encourages the innovation also. Okay, so it is well established that IPR advances and the product development, because it provides incentive for R&D commercialization. Okay, so that I'll show you this flow diagram, how it is happening. Even if you are the investors in the R&D institutions, naturally went to protect their investments and must therefore secure IP rights for their innovations. So when you will come to this slide, you see the importance. Suppose all the academic institutes, whether it may be a college or in, universities, so they should have some research fund for doing this research and development activities. So through that, we are doing a lot of research activities, and through the outcome of that research activity, we are developing many technologies and techniques. Okay, so that technology we have to give to the industries for the commercialization of that product. Okay, so we are not competent authorities, so we can develop the process and technologies. That technology should be combined with the industry people, and the industry, we have to tie up with the industries, and industry, they are the competent authorities to develop the product, to make the product. Okay, so that product, through that, there are many new products will come to the society. So ultimately the society, they are getting benefited. Okay, so this product, through that, we are also getting some monetary benefit. That monetary benefit will come to the again to the our research fund through the license fee and the royalties. Whatever the product is sold out in the market, then we are getting the royalties also, and the licensing fee also we are getting. So this amount we can use it for our research fund. Why I'm saying, but nowadays getting a project or external extramural funding, no, it is very difficult nowadays. And once if you have started this kind of practices in your institutes, you can also generate the revenues you can generate, and that revenues you can use it for your research purposes. That is the main importance of IPR practicing in our colleges and universities, right? Okay. So now we'll come to that, the patent, no, altogether, the overall, how we can define that patent. Okay. So the patent in the sense, like we should have some three criterias. You should satisfy three criterias. The prime one is the novelty. Once the novelty is not there, then your patent will not be granted. Okay. And also the inventive step. Then third one is the industrial applicability. That is very, very important. Okay, the commercialization. So these three criteria are very, very important when we are thinking about filing the patent. Okay, or any kind of IPR. Okay, so it should satisfy three criteria. One is novelty, and second one is inventive step, and third one is the industrial applicability. Once if it is everything is there, then you can prepare this document and you can file that document at the patent office. And the patent office, what they will give? They will give this exclusive right to the inventor. Okay, and for a particular term, 20 years they are giving the agreement. After that 20 years, your inventions will come to the public domain. Okay, and that 20 years you can get a monopoly rights, and you can transfer your technology to many industries and other kind of product development you can do. Okay, so this is all about this patent. Okay, and even in the many developing countries, like have in recent years come to recognize the importance of IP protection to the development of their economies also. So that is why the IPR protection has become a pressing issue with respect to the international trade. And even when we are talking about this innovation, innovation is nothing but something new that improves a product or a process. Okay, already it is existed something. So if you are going to do any modification or something to improve that already existing product or a process, no, that we will get. We can say that some innovative ideas involved in that. So many innovations can be protected through IP, intellectual property rights also. Okay, and an invention is a new solution to the technical problem and can be protected through these patents. Okay, if you have any a new solution for existing technical issues, some problem, that you can protect it through these patents. You can find out, you can sort it out that problem, and you can file a patent for that whatever that you have given the solution for this existing technical problem. So that is. And how can you protect apart from this patent also? There are many things involved. I told you, um, like um, a patent, like a copyright, trademark, trade secret, geographical indication, and traditional knowledge. There are so many things involved. Okay, and patent generally they are giving these inventions. Okay, so any technological inventions that they will give as a patent, and a copyright. You know that mm, like in the authorships. Okay, so there, if you are writing a book or if you are developing some software or something like that, so you can go for this copyright registration. Then trademark, brand name they will give. Okay, and even these kind of things, it is very important in the higher education also. What is the role of this intellectual property in the higher education? If somebody is asking, because in the emerging scenario, the range of students that would benefit from this intellectual property education is very wide, which includes students from different disciplines also, from engineering or science background or arts background. Anybody can do this IP. Okay, for arts background also, they can think of this copyright and trademark and trade secrets, everything they can do. The design registrations, everything. Engineering students, they can go for the patent and engineering as well as the science students. And they are having a lot of chances to get a design registration and a patent and GI also, geographical indications, everything. Okay, so keeping in view that the needs of different disciplines, well-crafted IP courses required to be devised out of which some of them are more relevant than others of the professionals. Okay, so even for the law, business, and engineering programs also it is available. Even in science stream, some knowledge of IP will help in creating the scientific temper for innovation and innovative activities, and how to reap the benefits of the one's own creation among the students also. So all these things involved in that the IP. Okay, and when we are talking about this importance of IPs also, the present knowledge technology era, no, like the intellectual property plays an important role as a driver of economic growth. But already I told you, the value of intellectual property lies in the commercialization and not in the mere creation and development. Okay, so that is very very important, commercialization part. Okay, and people used to say that IP is one of the potentially intangible assets that the business acquire, and it is utilized in the networking aspect also. And when we are talking about this, the protection of your intellectual, the inventions and other aspects through different kinds like the patent, copyrighted, trademark, and everything. And also we should we should know about this the types of patent also. Okay, the types of patents, and there are two types of patents. One is the patents like the product patent. Generally, the mechanical items or synergistic compositions, they are giving these product patents. Okay, the other kind is another one is the process patents. Okay, the process relating to the food or drug and medicinal items. No, so there you will get a process patent also. So generally, the product patents provides monopoly rights to the patentee for restricting others from manufacturing or producing the same product by any means. Okay, so that is product patent. In a process patent, otherwise we can call it as a method patent, provides the monopoly rights to the patents to restrict others from manufacturing the product by the same process for which he has got a patent. Okay, so that is a process patent. That is otherwise we'll call it as a method patent also. Okay, and when we are talking about this, the copyright and trademark, the design also they are giving for this apparent, the exterior, the designs. You take any instruments or any machinery items. For that you can go for the design rights. It protect the shape and form of protect the shape and the form of a product. Okay, and that is like what it looks like in the exterior things. No, like in not in the functional aspects. Okay, in the functional aspects, we can go for this patent, but in the designs, only the exterior kind of that shapes, that we can go for a design registration. And also the many companies, they invest a great deal of time and money in the coming up the new and attractive designs. They are making different kind of the designs, so they are also registering for that. And these kind of designs that seduce consumers into buying their products. And the design also is now widely recognized as a key determinant of commercial success also. So people will see the design and it looks very fancy and very small one, tiny things. These kind of designs, people they are coming to purchase it also. Okay, so for commercialization purpose, this design registration, design right is very very important. And also the semiconductor chipset designs also, this comes under this design registration. And nowadays some of the specific the software solutions and the semiconductor chips, they are also giving the patent also now. Some amendments they have done it. And the trademark also is very important when we are talking about this trademark. No, the trademark are signs. It is only sign, logo or a sign or word or kind of things like that are capable of distinguishing the goods or services of one enterprise from others. Okay, so the trademarks are indispensable tools in today's business world. Okay, and they help companies expand their market share, and they help consumers identify the products they want to buy in crowded marketplaces also, because everybody is nowadays they are talking about this trademark only. So people, they want some brand name. Okay, so that means it's not a fancy, it is having some quality also in that trademark. Okay, so that is with this trademark also. And the trade secret is nothing but like they can be used to protect the know-how of a business. Okay, so people used to say that only the Coca-Cola and Miranda, the ingredients, no, only the two companies of CEOs only knows. So that is why we call it as that is a trade secret also. And geographical indication, that is very interesting one. Really, the nowadays many people they have involved with this geographical indication. In Tamil Nadu, we have more than 38 products already. They have registered under this GI, geographical indication. And this geographical indication in relation to only goods. Okay, an indication of goods such as agricultural products or natural products or manufactured goods as originating or produced or processed in a particular territory of the country or a region. Okay, so that locality, so they are giving this geographical indication. Like that the Tirupati Laddu and Dindikal Puttu and Madurai Malligai. Recently, they have given GI for this Kovilpatti Kadalamitai and Kodaikanal Malaipundu also. Okay, Kodaikanal Malaipundu, they have given this GI. And because where a given quality reputation, no, for that particular product or preparation of the goods concerned um, taking place in such a territory of that region or locality. So for that, they are giving this GI. And the traditional knowledge, that we cannot patent. You cannot patent these traditional knowledges. Okay, so because it is already many people they are used, and it is a generation to generation it is coming. Okay, so you cannot copy that traditional knowledge, and you cannot claim that I have found some of the new ideas are like that. So it cannot be patented. But some traditional knowledge, if you are doing some scientific validation in that, you are adding some value added in that, then you can go for patenting. That we'll see later. And another one is the Plant Variety Protection and the Farmers' Right Act. This is a different aspects. It comes under this Institute of Indian Council of Agricultural Research, ICR, and Plant Variety Protection and the Farmers' Right Act. There you can under this act, the breeders like will have rights to protect the new variety of a plant, like in the quality wise, even the yield. The yield may be more like in the seed bigger, no, like hybrid seeds and all they will produce. And some plants they will develop for their disease resistance also. So this kind, the breeders they will use to get this protection for this new variety of plant. And this right under this act include the right to produce, sell, or market directly to export a variety also. This comes under this PPVR. Okay, and the breeders' right have been strengthened to extend if there is a mere suspicion of violation of infringement. That is very important. Okay, these are the different types involved in that IP, and now we can see the terms of different IPs. Like how many years they are giving the monopoly right to the IPs. When you are filing the patent, so you can get a 20 years from the date of the filing, not from the granted date. Okay, suppose if you are filing the patents in 2020, you will get up to 20 years. That means 2040 you will get that patent rights. Okay, and maybe your patent after 10 years also it may be granted, but that doesn't matter. But from the filing of the date, it will go for 20 years counted. Okay, and trademark 10 years they are giving, and maybe renewed for an unlimited period. You can pay that renewal fee also, just like for others also, like the designs. You can go for 15 years they are giving, then you can pay the renewal fee, and you will get your patent will be renewed. And the geographical indications, 10 years they are giving, and also maybe renewed for an unlimited period. Copyright, it's the author's life plus 60 years they are giving. Okay, and integrated circuits, 10 years they are giving. Okay, so this is the different terms of IPs. And trademark, when we are talking about this trademark, I already told you that it is recognized in the world, and the word or logo or something like that. Okay, you can see here these pictures, and immediately you will come to know that what is what. Okay, like a Tata and Fenner and Cadbury's, Bajaj and Nike, everything. Okay. So these are the things that are involved with the trademark, and people come to know that easily attracted also, and also quality. The quality is good. That is why people they are going for this Nike and other kind of the shirts also, like shirts, no, many shirts in the Louis Philippe and Van Heusen, these kind of shirts. It's having some quality. That is why people they are come forward to take. So all these are comes under this trademark. Okay, and even the companies, the why companies also changing their logos. You see, previously the Canara Bank it is like that. Now it is they are changed to this Canara Bank logo also. Okay, so people will like and they also need some changes in these aspects. And you see this Apple computer, no, like this MacBook and this your iPhones, everything. The symbols they have changed in 1976. How this iPhone symbol, but now you see that they have changed everything. Okay, they have registered under this trademark, like just like this Starbucks coffee also and Coca-Cola logos you see, and now presently it is like this. Okay, and when we are putting this R means it is already registered. Okay, so and this Pepsi, it is also like that. Few examples I'm showing. Even in the India Post, you can see here how they have changed now recently, and Air India also, the logo they have changed, right? And to the trademark have some meaning. Yes, definitely. I think you know very well this Amazon.com. That yellow arrow is not a just a smiley. It also suggests that you can buy everything A to Z. Okay, so that, and also these families you can see here. The families is a readers Digest magazine, and the letter ILI, like the center, the ILI, or transformed to show a simplified and a stylish family of three. Okay, so it also having some meanings. Okay, and we should also know about this in the criteria. So just like in the patent, we should have three criteria. One is novelty, and another one is inventive step, another one is industrial applicability. That is a commercialization value. So like that, when you are going for the trademark registration, also it should have satisfy three criteria. That is, one is a non-descriptive, non-generic, and not identical. Okay, or similar to existing marks. So non-descriptive in the sense Apple for computers, it is a non-descriptive. iSoft for software is a descriptive one. So we should have some non-descriptive words like Apple for computers. There is no meaning. There is no relation between Apple and the computers. Okay, so like that. And non-generic, Avian for supermarket, it's a non-generic, and Stop Shop for a supermarket is a generic one. It implies that shopping. Okay, but Avian is, there is no meaning for that for a supermarket. Okay, so that it should be a non-generic and not identical, of course, because nowadays many people you can see in the market also, they will simply they will change the letters. One letter they will change, or they will add one letter, but in the pronunciation will be the same. Okay, so it should be not identical also. So these are the three criteria when we are going for these trademark registrations. And what is protected as a design, we already discussed. And the exterior, the aesthetic aspect of an article or equipment, no, that we can go for a design registration, not the functional aspect. Once if you are talking about this functional aspect, then we can go for the patent registration. And what can be registered as a design, as like happening in the trademark and patent, no, like it should be a new or original one, novel, and not previously published also, and significantly distinguishable from known designs. Excuse me. And also because these are the three things like is very important, the design. Okay, and so copyright already we have discussed, and the copyright is an exclusive right given to the creators. Okay, and provided by the copyright law to an author or artist or composer or an unauthorized personal for a fixed period to print or publish or sell the copies of his her original work. Okay, for that we are giving the copyright. In other words, copyright means the right to copy or reproduce the original work in which the copyright subsists. Okay, and the copyright subsists in the work as soon as it is completed by the author, and remains in force to 60 years even after the demise of the author also. And this registration of this copyright is not obligatory, but it is a proof of ownership only, and can be used in a case of some litigations. Okay, and we can protect these copyrights through literary or dramatic or artistic work, musical work, and cinematograph film and work of architecture also, that we can go for copyright. And for us, academic purpose, like whenever we are writing a book or editing a book or writing the manual, that we can go for this kind of activities. We can file this copyright, do the registration. Okay, and we have talked about this geographical indication of Indian logo. This is very important. Recently, I told you that the geographical indication, you see here, geographical indication is a sign or tag identifying a product originating in this particular certain territory, where it is given a quality. Quality is important. Okay, the particular place is the quality and the reputation and some special characteristics of the product, and these all this important with this geographical indication when we are going for this registration of GI. Okay, and also it do not confer individual rights, just like the patent. No, patent can be given to the individual, okay, inventors, but GI will be given to a group of people only, the association, those, and owned by community and association of producers, like if a Nilgiri teas. So the tea growers, they can go for a GI. Okay, so like Assam tea growers and suppose Kanjipuram sarees, the weavers association, they can go for geographical indication, not any individual, just not just like a patent. Okay, and yeah, and in this GI, it denote the quality and origin of products, and a good reputation also is there, and prevent the goods from becoming a generic, and protecting the domestic market for the competitors also. Okay, and it's having some legal protection when we are doing this GI. So you will get a legal protection also, and the local producers and farmers get benefited definitely, and rural development will increase and reduces unfair trade practices also. But nowadays, no, like in the product, people, they are making alwa here, and they used to sell the Velveli alwa like that, because in the particular place that product should come, then only that reputations and the quality you will get. Like Madurai Malli means that flowers should come from that particular region. So in other places also that Malli is there, but we should give importance to that kind of GI, and then only we can bringing that quality on. Otherwise, there are many people, they will do some duplicates also. And in we can also by doing all these things, then we can preserve the local culture and resources. That is very important, and also provides complete information to the consumers. Okay, and the process how we can go for this GA process, because I told you this Kodaikanal Malaipundu, the Mother Teresa University, Women's University, the Department of Biotechnology faculty members, they have supported, and they have helped the farmers to get this GI for the Malay and the Kodaikanal garlic. Okay, and this geographical indication of goods, like the Act 1999 came in force with effect from September 2003, and we have in Tamil Nadu, we are the number 2 in India to have more GI also. First one is, I hope it is with Karnataka, I think. After that, the Tamil Nadu has having a more GI registration. Generally, in the registration, they are giving for agricultural goods and manufactured goods and handicrafts. I think you know all these aspects, and it is given only for this, the association of the people we have already seen. And this application, when we are going for this GI application, no, it required a lot of information also. You have to produce a lot of information, support that documents, like a name, logo, significance of the product, geographical area, method of obtaining the product. There are so many things, and that once if you are producing all these things, then you can submit this application to the GI registry in Chennai Patent Office. It is there. Then after 30 days, then after some period, they will also evaluate, and they will see all the things. Then finally they will register the registration they will give. And this, it is unlimited period they are giving, but every year you have to go for the renewal also. And the GA cannot be used for these mortgages and license, unless like patent. No, patent you can go for mortgages and license, but the GA cannot be. Okay, And these are the India's famous GIs: Banaras silks, Pashmina shawls, Bengal cotton, basmati rice, Assam tea, and all. So why I'm giving a lot of importance for these GIs? No, as a academicians, no, we can just in and around some people, local people, no, they are having some specific unique product or unique food items they will prepare or something. So you can just go and talk to the people, and you can also involve them with that, and you can try to help how to get this GA and all. So in that case, if you are helping and you are also one of the partner for that GA, and your name also will come in the GA registration certificates for this Kodaikanal Malipundu, and Mother Dasa University name also is come. I will show you the certificates. So these are some of the examples for this GA, and this is Tanjavur Vinay they have registered. This is the registration certificate for that. And what I told, that is GA for logo, that is Kodaikanal Malipundu. And here you can see this the Department of Biotechnology and Mother Teresa University. They are also involved in this getting this GA registration. And like that, we can also try in your area nearby, like any local people, they are doing some unique kind of activities, or any cultivation or anything, any product is comes out from that kind of activities, that we can go for this GA registration. And for this, they have taken literatures from very old literatures from this Madras journal also. They have mentioned about this particular Kodaikanal Malipundu, and it's having a lot of therapeutic value. So that is why they have easily got it. And the storage, how they are storing this garlic after harvesting. So everything it is having a value. Okay. And they showed that even in the cultivation also, it's having some a different kind of cultivation they are following. So all these things they have supported, and finally they have got this GA registration for. And one of the articles shows that this grading also, like the Kodaikanal Malipundis comes under the first grade, and the price also it is very high, and 170 to 220, and definitely the farmers will get benefited. Okay, so once if you are doing this kind of a GI for giving value to that particular product, so definitely the farmers, the local farmers, they will get benefited a lot. And when you are coming about talking about this traditional knowledge and all, so we should know about this biopiracy also. So biopiracy is nothing but is a use of indigenous knowledge of natural resources for commercial applications without the consent. Okay, so you know very well many cases happened in India, the turmeric and neem, because we are using this kind of turmeric and neem for many wound healing activity and pesticidal for activities. We are using it for many years, thousands of years. Our forefathers, everybody is doing, but we are not protecting it properly. And some other people, US and European people, they have patented. Then finally, we have revoked that patent also. So that we will call it as a biopiracy, and with little or no common sense or recognition to the community from originates. Okay, so that also nowadays the NBA, National Biodiversity Authority, is giving a lot of emphasis on this. And once if you are taking any product or any material collecting from the biodiversity, we have to inform to the NBA, and we have to sign with that access benefit sharing mechanism also. Okay, and some important this traditional knowledge, like no patents on traditional knowledge of country, that is sure. So we cannot patent for this traditional knowledge. But once if you are doing some scientific component, scientific validation, or if you are adding something to that, and it's having some other therapeutic properties, and it cured many diseases or like that, then you can go for this valid the patent application. And there also you have to disclose these geographical places to be disclosed very clearly. And is there any traditional knowledge involved? That means which local people, the traditional communities they have involved, everything you have to mention in the NBA application. Then only they will give permission. After getting granted your patent, then if you are making the product, then if you are getting a revenue, and that revenue, 50% of the revenue should go to the local people, and 50% you can enjoy. Okay, that is the access benefit sharing mechanism developed by this NBA, National Biodiversity Authority. Okay, so there are many traditional knowledge they have already documented. CSS, Council of Scientific and Industrial Research, they have started this digital TKDL, that is a traditional knowledge digital library, and there many things that they have already documented also. Once if you are going for patent, so you have to check with this also. It should not come under this traditional TKDL. If it is there, then people will object also. Okay. And biopiracy, I told you this turmeric 1997, the US patent, they have got a patent. Then after that, our CSR has filed a case and they have fought with many, they spent a lot of money also and supported many documents for revoking this patent. And ultimately 1990, after 2 years, then the patent was revoked. And the NEEM, 1994, the European patent, they have granted this patent for a company based on this US Department of Agriculture for controlling fungi and plants using neem oil. But it is 1,000 years before also our people, they have used it for this neem for pesticidal activities, fungicidal activities and all. Then after that, 95, they opposed the patent and finally the patent was revoked in May 2000. And this is another one Indian case benefit sharing mechanism. I already told the access benefit mechanism. This is the first case happened in India. The Jivanani, it is a restorative immuno-enhancing anti-stress and anti-fatigue agent. This is that immune stress, immune-enhancing that product. They have developed from Arokya Bacha, that is a Trichobius zeylanicus, that tribal knowledge of Kani tribe in Kerala developed by this TBGRI. The Kani tribals, they are having this, they only told that it's having some anti-fatigue and immuno-enhancing agent. Based on that knowledge, the TBGRI people, the scientists, they started to work on that and they have developed and the technology in the process patent they filed and they granted and they have licensed with Arya Vaidya Pharmacy. They got 10 lakhs for that licensing fee that in 1995. Among that 10 lakhs, 50% of that license fee and royalty they have given to the Kani tribals for their society development. Okay, 50% it will, and the TBGRI people they have received. Okay, so this is that access benefit sharing mechanism. So this it comes under this this NBA, and nowadays the NBA is very strict. Whatever the material you are collecting from the biodiversity, you should disclose to the NBA and you should also do the MOU with this agreement, access benefit sharing mechanism also. And but many people nowadays, they are not bothering these things, and the NBA is always stressing the people that you should inform to the NBA whenever you are collecting some material and you are sending to the abroad for analyzing or getting some R&D result. No, you should get a clear permission from these NBA. But as a biological scientist and other faculty members, those who are involved with the research using these biological resources, they are not at all bothering. But it is not right. It is not a right thing. We have to always go with this NBA. And this the Farmers Act we have already seen. Okay, and now we can come to that. What can be patented and cannot be? Okay, so the first we should think that anything that qualifies as an invention can be patented. Okay, and the qualification is nothing but the novelty and inventive step and commercial value. Maybe it may be a new product or new equipment or machine or a new manufacture or a new process for with the technological advancement also. For that we can go for a patent, but only always the three criteria should be there. That is a novelty and non-obviousness, and must be useful and should be a practicable also. And what cannot be patented is there anything against the law of nature or physical phenomena, anything frivolous or contrary to natural laws, anything against the law and mortality and the negative thinking also cannot be patented. And treating diseases like medical and surgical, no, that cannot be patented. But the same thing, the medical equipments, the surgical equipments can be patented. And the duplication and rearrangement combinations without new informations cannot be patented. Suppose if you have a mobile and this mobile, you can change the colors or change the shape, you cannot get a patent. Okay, so if you have any specialized some features inside, some applications involved in that, then you can go for a new product. Otherwise, it is just like the rearrangement or combinations without any informations. And non-patentable, the method of agriculture or horticulture. So like in the cultivation of algae or cultivation of any crop, that cannot be patented. Like producing new form of a known plant or a preparation of an improved soil. Like you cannot say that I have developed a fertile soil and that cannot be patented because it is already existed in the nature. Okay, so that cannot be patented. However, agricultural equipments are patentable. That equipment, there are many equipments comes under this agriculture post harvesting technology. They have made many equipments and harvesting. They have new equipments are coming. That equipments are patentable. And the plants and animals in whole that cannot be patented, and parts of plants and animals also. And the seeds you cannot patent, but you can develop some hybrid seeds and you can register with this PPVR, that is a Plant Protection and Farmers Right Act. Okay. Uh, why we have to? What is the why should I obtain the patents? The question will come with you because to disseminate the research to society's benefit and also to level the playing field and stimulate markets, increase the value of an institution. That is very, very important. Once if you are practicing this IP, so definitely your institution value will increase and generate revenues for the institution also. I already explained clearly, and generate revenue for the inventor. Because apart from if you are getting this exclusive rights, generally exclusive rights in the innovator obtain exclusive rights through patents, which usually allow an inventor to exclude others from making or using or selling the patented invention for a particular period. That's what we are giving, and the patent office is giving exclusive right. Okay, and also we can dominate the market position also. The patent holder will be able to exclude others from commercially using their patented invention without prior permission, hence can enjoy the monopoly, and this will help to establish themselves as a preeminent player in the market. Okay, so we can dominate the market position also once if you are doing this patenting. And another very important is that better investment on the better returns on investment. That is very, very important. Whatever the amount you have spent to develop this product or process, so you should get the money also through that filing the patents. So rights to license or sell the inventions, patent owner, they will also get the license fee, royalty, and everything. Okay, so through that they can think about another enterprise also, which will be a source of income for your newer another enterprise also, and increase in negotiating power also. You can increase the negotiating power. So that is why we have to go for the patent also. If you are suppose if your enterprise is the process of acquiring the rights to use the patents of another enterprise through a licensing contract, your patent portfolio will enhance. Your bargaining power also will enhance, and you can get the cross licensing between the two enterprises also. So the negotiating power will increase if you are patented. Okay, and also it increase the like the value of an investment. That is a positive image for your institution or enterprise also. Okay, so these are the reasons why we got to go for the patenting, right? And how patent can support. So that is very important. How patent can support inventors and improve. Like the patents recognize and reward inventors also. Yeah. And also a new technology comes onto the market, society, so the stands to benefit also. And finance for the technological for development, it will definitely, it will helpful. Okay. And also the turns the inventors know-how into a marketable the assets, tradable assets also, and makes a small business more attractive. So these are the things that it will definitely it will give. And so once if you are doing all these things, definitely you can enjoy your monopoly rights. And if you are not doing it, what will happen? What are the consequences if you, and the consequences of ignoring to file the patent, or if you are not protecting your patent? So definitely somebody might patent. Okay, in most of the countries, the first person who applies for a patent gets an exclusive rights. Okay, so if you fail to protect your inventions, then somebody else may they get it. So that is why So immediately, whenever you have any intellectual ideas or any creative ideas, so immediately you go and file the patent first, okay? And the competitors will take advantage. Competitors will take advantage of your invention. Generally, your competitors use your invention without paying royalty if you fail to protect your invention. Okay, so if you have done your patent filing and protecting, no, definitely they have to get a permission from you and they will get a license from you, and you can also generate revenues through license fee also. This may considerably reduce your market share for the product also. Then the competitors will get ready-made technology without spending much resources. You might have spent a lot of money, lot of time, and you have spent to get that new technology or new techniques. Okay, but if you are not protected, then other people they will take your technology. Okay, and the possibilities to license, sell, or transfer the technology will be severely hindered also. Without the IP rights, transfer of technology would be very difficult. Okay, so that is important. So patent protection is important to acquire this technology through its licensing also. And if you forget to do it, will not be able to get the generate revenues, will not be able to obtain return on investment also. Yeah, so we have come to the final, and this is one of my patent granted recently in 2019 November. The patent granted from our research group, the dietary supplement and the method of manufacturing the dietary supplement from seed embryo of Palmyra, that is Borassus flabliver. We will call it as in this Panemaram. Yeah? So we know that all the parts in Panemaram is very useful. Even some parts is edible also. Okay, but what we have done it is on the underutilized part, that is a seed embryo. So once in the ripened fruits, after that in the ripened fruits, if you are breaking it before coming to the root, the shoot formation, no. So once if you are breaking that, inside you will get a seed embryo. That seed embryo is having a lot of nutraceutical value. That we have developed the process, how to process that seed embryo into a powder, and that powder is having a lot of nutritional aspects. Also, it's having some anti-stress property also. So now it is in the process. We are making, we are developing a product for this one. Very soon it will come, and this is our. We have done it in Bharatiya University, our research bioprospecting laboratory, and myself and my scholars, Dr. Arnachalam and Dr. Saravanan. Now they are in Brazil, they are doing postdoc. So we have developed this technology, and it is appreciated by many people, and we are developing now, we are converting into a product. So very soon it will come to in the market. And when we are doing this kind of the patent filing, no patent filing, so we should know that how much cost will, like it will take, like people will ask, sir, how much we have to spend for this to do the patent filing. So when we are going for individual filing, that means like suppose if your college or university don't have this IP cell, excuse me, so you can have this individual filing. If you are going, only will 9,900 will come. But once if you are going for this organization, through organization, then you have to pay around 44,500 rupees. So when you are working in a college or university, so you have to go through organization only. That means the applicant name will come as your university or college name. Applicant, patent applicant. Okay. So the inventors, you can be there. Okay. As an individual, inventor will be there. But the patent applicant always, whenever you are working in an organization, the college name or university name will come. Okay. So these are the essential forms that we have to fill it up, and we can file the patent. So how to start these kind of things, like in your, suppose if you want to establish in your college or universities the IP cell. So training of faculty students it is an ongoing process that we have to create awareness among the people, and IP audit to find out the innovations in your institute also. You have to make many we organize meetings, and we have to get a lot of innovative ideas from the students and the faculties. and documents all the innovations, whatever the innovative ideas are there, you please document it. Don't say that this is very simple, it's not innovative. Take all the innovative ideas and keep it and evaluate. After that, you have to analyze, evaluate them. If someone of them are a good to be filed as a patent or copyright, something will come out from that innovative ideas. Okay, don't discourage. You encourage all the students and faculties innovative ideas, and also have stringent IP policy, because we have to develop this institutional IP policy also. So that IP process we have to start. Okay, so once if you are doing all these things in your institutes, definitely you will get, these are the outcome you will get. That is what will happen after doing all these things. The quality of research paper will definitely will improve, and branding of the institute, that I already told you. Okay, the value, it will increase the value of the institution, and the students are industry ready, and the placements will be a better one, and you will save money and time also. Okay, so these are the things that when you are going to start this IP in your institutes. Okay, and some of the major challenges also there to commercialize these R&D results, no, and lack of IP management and infrastructure in your institutes, and lack of strategic research planning also, and gap between basic research and market needs, lack of funds for IP protection. Okay, every institute should support also, the management should support to meet out all these expenses for filing the patents and all. For our university, we have a fund, and our authorities, they are supporting to file the patent and everything. Up to that granted also. After granting also, we have to go for this renewal. That renewal fee also we have to do. So everything our university is taking care. And lack of IP knowledge, that we have to go through this awareness program only, and lack of expertise to manage this technology of transfer and the commercialization process. That also we have to take care. Otherwise, it is very difficult. And lack of entrepreneurial skills, and lack of support and incentive. Because whenever if anybody is doing filing the patent, or the management should support, and they should give some incentive or some appreciation, something they have to give. Okay, so these are the things. Once if you are taking care of all these things, then definitely we can we can get a lot of patent file or other kind of IPs we can register. And this is overall thing is like how to file the patent and all. The filing patent, no, like whatever the innovative ideas, if you have, just make a techno-legal document, and just file, go to a patent office and file. After 18 months, it will publish in your the patent journal. For that also, early publication is permissible, and you have to pay some thoughtful fee. So in that case, within 3 weeks, it will be published. Okay. Then after that, you have to submit this form also, request for examination. So within 48 months, you will get a request for examination. Then the first examination report will come within 6 months. So you have to submit the response also. There are many queries will come. They will give the 6 months time period. Within that 6 months, you have to submit the response. Otherwise, your patent will be abandoned. Okay, so response submitted, and after that, after once the response is submitted, then you will call for the hearing. So then the further examination also will be there, and the hearing they will ask some clarifications. After that, if they are satisfied everything, it will be granted, or otherwise it will be refused. After hearing also, the patent will be refused. Then the grant, sometime the 50-50 chances, whether it may be granted or it may be refused. Okay. So once if it is granted, then the grant notification will come in the patent journal. Then after that, the post-grant opposition also is there. So we have to be very careful, and we have to, because that is why that novelty should be there. Once if the novelty is not there, anytime the problem will come. Okay, your patent also will not be granted. Even if you are granted or copied something like that, the post-grant opposition will come. That time again, your patent having a 50-50 chances, whether it may be granted also or maybe refused also. Okay, again you can go for appeal. Then you will get once if you are satisfied all the things, then the patent will be granted. So this is the overall filing process, how to file the patent and what are the things involved in that. Okay, So once if you are filing within 3 years, you will get a patent rights. So these are the things involved with the filing process. Okay. And yeah, I think with this, I will just conclude the patent innovations and IPR, because the importance of intellectual property in the modern world goes far beyond the protection of the creations of the mind. Okay, so IP is a powerful tool. I already explained very well. It is a powerful tool of economic growth for stimulating the creativity and the innovation and generating revenues, promoting investment, also enhancing the culture, everything. Okay, and it affects virtually all aspects of economic and cultural life, and it has become an important component of business transaction also, this IP protection. Okay, um, so new and innovative ideas are key aspects of most successful business, and particularly in the higher educational institution, it is very much needed nowadays. I already told you about this NARF and NAC scoring and all. So we have to develop and we have to practice this IP culture in our higher education institutions. IP, like intellectual property, particularly patents, can be vital to convert a new and original inventions into a competitive products that considerably increase the revenue generation also. This will help our a lot for our higher educational institutions, and we can also enhance our institutional value by doing this IP culture in our academic institutes. So thank you so much, and I thank the authorities of the APC College and the organizers and all the participants also. So they patiently listened for more than an hour. And if you have, and I am asking the participants, if you have any questions, please you can ask me now.
Thank you, sir. Thank you for our excellent and informative lecture. I hope all the participants have gained knowledge on how to file patent and how to get copyrights. You have explained everything in a simple and easy manner. Now the session is open for discussion. Dear participants, please unmute yourself and ask your questions. Dear, please leave the question posted in chat box.
Somebody, Kanapati. Otherwise, you can ask from that chat box, no?
Okay, so shall I raise the question, sir?
Yeah, please, please.
A question from one participant.
Yeah.
Sir, can I sell my patent if I don't know how to market it? What is the legal punishment for missing others' patent?
What is that?
What is the legal punishment for misusing others' patent?
Why you are thinking in that way, negative way? And why you want to do infringement? We should not do the infringement. Okay. Then if you are doing this kind of copying, then you will not get any innovative ideas, isn't it? So very strict legal punishments are there, but I didn't include in that. Even the you will be jailed also for some years. That part I didn't include. If you are doing infringement or others, you will get a jail term also. So if you want, I can send you through mail. But don't do the infringement and all.
The next question: can we get the patent for standardized herbal products?
Yeah, definitely. Herbal products in the sense you have to some novelty should be there.
Oh,
some novelty should be there. And whatever I told you, that the three criteria, that novelty and inventive step, that is very, very important. How you processed or how you made that product, that clear inventive step should be you have to disclose, and a commercial application also should be there. Herbal product in the sense just a mere admixture of 2-3 herbals and making a product, that they will not give also. Okay, so you have to scientifically validate or scientifically prove that what are the components are there, that particular component is having some therapeutic value. So once if you are doing all these things, then you can go for a patenting. It is possible.
The next question: What is the validity of GI tags, sir?
Ma'am?
What is the validity of GI tag?
Yeah, GA, I told in my slides, I think more than every 10 years, I think they are giving. After that, every 10 years, you can renewal also. There is no problem with that.
Next question, sir. Renewal time for patent filed. Renewal time.
Renewal?
Renewal period for a patent.
Yeah, once the patent is granted, then they will inform. Every year you have to renew.
What are the issues that are facing negligence regarding implementation?
Which one, ma'am?
What are the issues that are facing negligence regarding implementation?
What are the issues in the sense I have already explained in the slides clearly. If you are ignoring to file your patent, no, so you will not get any benefit. That's all. Other people, they will go and they will file the patent and they will get all the benefits. And you will not get any revenue generation also. Whatever you have spent money to develop that technology or process, you won't get.
Okay, sir. Next question. What is the time duration required for patenting any innovation?
Yeah, it depends upon the discipline, ma'am. Like if it is a engineering or biological science or mechanical engineering or like that, based on the application numbers, no, the year, suppose if, the application number is increased, then you will get little late. And whenever the first response is coming to you, first examination report, that is FER, so they are giving 6 months. Don't wait up to that 6 months. Within some 20 days, you can finish that thing, you can send also. It is everything is based on the priority only. So we no need of any influence or in nothing. Okay. So once if you have filed the patent, so within 3 years you will get. Even for our university, 2016 we have filed one patent in the medical physics field. 2019 she got it. So within 2.5 years she got it. So it depends upon the discipline also, which field you are applying for the patent.
Next question, sir. If a patent is given by a specific country, then is it applicable to other countries?
No, ma'am. So each country you have to go for a separate filing. Suppose India first, before going to other countries, first we have to file the patent in Indian patent we have to file as a citizen of India. We have to file the patent in India. Then within 12 months, if you want to file a patent in other countries, you can go and you can file. So each country you have to give a separate application.
Next question, sir. What are the incentive mechanisms followed in educational institutions?
Incentive?
Mechanism followed in educational institutions.
Yeah, incentive is nothing but giving appreciation or giving some monetary value, some award or rewards they can give. That's all. Once they are giving, they are encouraging, that will do. No, appreciation is more than enough. But many people, they are not doing it.
The next question. If we get sponsors for new product development, whether we have to include the sponsor's name while patenting?
It depends upon that agreement what you have made with your sponsor. Let's suppose the DST or DBT funded project, no? So you no need to give DBT to include. Just the only thing is that we should inform to the concerning authorities before filing the patent. We have to get a no objection also. So that is very much important. So sponsor, whether they are willing or not, that we don't know. So anyhow, but you have to get a no objection certificates from that counterpart.
One more question, sir. Please share patent registration in details such as whether we register directly or through agency, fees, duration, etc.
Yeah. So this is very important. Good. At least you have asked these things. The registration can be done by individual also and through online also. Otherwise, you can go to the Indian Patent Office at Chennai, Gindi, it is there. There you can file your patent. So there are online also you can do. For that, a digital signature you have to get it. Then you can file through online. Suppose if you are working in institutions like college or universities, that you have to get a no objection certificate from your institutes. Otherwise, if IP cell started in your institutes, you cannot go through, you cannot go like individual filing. You have to go through IP cell only. In that case, the university name or college name will come as a applicant name in the patent. Inventors, you can be there, individuals. And once if you have filed all these things, it will take within 3 years, the patent will be granted if you are following all the rules and regulations very strictly.
Okay, sir. There are some participants with some questions. Participants, you can now unmute yourself and ask questions.
Hello.
Yeah.
Good morning, sir. Good morning, sir. It was hello.
Yeah, morning, please.
Here. Sir, it was nice session, and I have one question regarding the provisional patent. Provisional patent. If a person is going to failed to work on that particular provisional patent, then what will be the remedy to him?
No, the provisional patent. Suppose if you have.
I'm not. Suppose in a year there is a 1 year limitation.
Yeah.
For provisional, and I failed to do that particular research work. Okay, whatever I mentioned in that particular patent, then what will be the remedy?
Remedy
what will be the what I have to do further? Again, I have to file for same thing or lots of disturbances there.
And you can ask whatever she asked.
What is
பெரிய கடைகளை பொறுத்தவரையில் அதிக அளவில் மக்கள் கூட்டம் கூடும் என்பதன் காரணமாக சமூக இடைவெளியை மக்கள் பின்பற்றுவதை கடைக்காரர்கள்
Hello, sir. Hello.
Yeah. I'll give.
Sir, please unmute yourself, sir.
Ma'am, I'll give answer for that one question raised by one scholar, I think. Hello. Is able to hear my voice?
Yes, sir. Yes, sir. Carry on, sir. Continue, sir.
So actually, the provisional patent you can file, and within that 12 months you have to file the complete specification. Okay. If you are failing to do, then I don't think that. I think sometimes they will get abandoned also the patent, or otherwise you have to pay some penalty fee. So there is the chances are there. I think. Hello.
Sir, proceed. You can proceed now, sir.
Yeah, I already answered. So any questions further?
Almost all the questions are answered by you, sir.
Pardon?
Participants?
Sir, almost all the questions are answered, sir. No more questions.
Okay, ma'am. Then in that case, I thank all the participants and the coordinator and the principal, everybody, to invited me to share my views on this innovation and IPR. Thank you so much.
Thank you, sir. Thank you, sir.
I request Dr. Shanmugapriya, Assistant Professor of Chemistry, to propose formal vote of thanks. Priya, please.
Yeah. First of all, I thank our university for the grand success of the program. I would like to thank our Honorable President, Principal, and Director for their support. On behalf of the Department of Chemistry, I thank the most Honorable Resource Person, Dr. T. A.P.C.Mahalaxmi, Director, IPR, Bharatiya University, Coimbatore, for his excellent and informative lecture. Thank you so much, sir.
Thank you, ma'am.
Special thanks to the participants for their cooperation. Once again, and thank you, one and all. Thank you. Thank you so much, sir.
Thank you, sir. Thank you so much.
Thank you, ma'am.
Dear participants, fill the feedback form as early as possible. Feedback link has been posted in the chat box. Dear participants, fill the feedback form.